Hello everyone, welcome to Legal Darshan. In this video, we are going to look at the case of In Re Special Reference number 1 of 2012 under Article 143, Clause 1 of the Constitution of India. It is a 2012 judgment and it is numbered at 27 in the list of AOR leading cases being decided by a 5 judges bench comprising of Justice Kapadia, Justice D.K. Jain, Justice Jagdish Singh Keher, Justice Deepak Misra, and Justice Ranjan Gogoi. Now, in this case, we are majorly going to deal with Article 143 powers of the Supreme Court, how the President and Supreme Court interact while exercising the powers under Article 143 of the Constitution of India. Now, a brief fact of this case is relating to 2G spectrum case and article in 2012. Okay, so in 2012, we must remember that India witnessed the explosive 2G spectrum case. Okay, the Supreme Court cancelled 122 or more telecom licenses, criticized the first come, first serve method, and emphasized that option is the preferred allocation mode. Now, the question that is being raised in this case is that whether auction is mandatory for all type of natural resources like land, coal, minerals, and more. And therefore, to clarify whether auction is the only viable method to, that applies to all type of natural resources, presidential reference is invoked in this case, and the President of India invoked Article 143, asking the Supreme Court to render its advisory jurisdiction in exercise of Article 143 of the Constitution of India. So the question that the court is adjudicating herein is that whether auction is an only constitutionally permissible method of allocating natural resources. Now the Supreme Court held that it is not necessary that only an auction should be done. Okay, only an auction should be done. It is not necessary that it can be done for all the allocation of all the natural resources. The court is basically saying that auction is preferred because auction is constitutionally favored, and it is also transparent and it promotes fair competition, but it is not always required in exercise of Article 14. There can be other method of allocation also which may remain valid in the proper and appropriate context. So now court is clarifying that its decision in the 2G spectrum case was only specific to 2G spectrum, which is a scarce natural resource of the airwave, and it is not establishing a universal rule for all the natural assets. Right now, on other resource allocation methods, the court is saying that those methods are also constitutionally permissible, but the mandate is they should be fair, they should be transparent, and they should be non-discriminatory, because if they're not fair or not transparent, or there is a scope of arbitrariness or discrimination by being happening by those methods, it can violate Article 14 as envisaged in the Constitution of India. Now the court is also saying that the other allocation methods apart from the auction, they may include regulatory grants, administrative allotment, preferential schemes, or even first come, first served methods, as long as they uphold the legal standards and protect public interest. Now, the court goes on to also expound Article 143 in this case. Okay. Now, the court is basically looking at Article 143 in this case. And when we look at Article 143, the court is holding that president that the situation arises that does president really have to need a doubt, that president really needs to wonder whether president is in doubt, only then can reference be valid? But the answer is not. No, court herein is saying that as long as the referred question is of public importance and needs constitutional clarity, the reference is valid. President need not be in a factual or law-based doubt for the same. If there is a question requiring constitutional clarity and the question pertains to public importance, the reference remain valid. Okay, the existence of a question of law or a fact that is of public importance is sufficient, irrespective of the fact whether the president is in doubt or not. So whether the doubt arises with president is not material in this case. If there is a question of law or fact that is important for public policy, and the president is invoking Article 143 jurisdiction herein, that the court can entertain such matter, and court can look into the issue that has been raised by the President of India. Okay, so now, when we look at Article 143, the Article 143 is if at any time it appears to the President that a question of law or fact has arisen or is likely to arise, which is of such a nature and of such public importance that it is expedient to obtain the opinion of the Supreme Court upon it, he may refer the question to that court for consideration, and the court may, after such hearing as it thinks fit, report to the President its opinion thereon. Okay, so now the another thing that the court is looking herein is that whether this opinion, number one, whether this opinion is binding in nature, the opinion rendered by the Supreme Court to the President, what kind of opinion it is. The court herein is saying, clarifying that the judgment, that the order or the response given under Article 143 jurisdiction, it is not something that the court is adjudicating, but rather it is only advising the President regarding the constitutional clarity on the issue. Therefore, the response that the court might give under Article 143 is not a binding judgment, but rather it is advisory in nature. However, it does carry immense persuasive value. Government officials usually follow it. They have to follow it, but they may follow it, but they aren't legally bound to do so. So advisory is not always enforceable or is not always binding, but it is highly persuasive. It is highly respected by the government official. Now, another question is, the court also is expounding whether the court, in exercise of Article 143 jurisdiction, can it deny to answer certain questions? The court herein is saying that Article 143 of the Constitution of India is couched in broad terms, and from its language, it is plain that it is not necessary that the question on which the opinion of Supreme Court is sought must have actually arisen. The President can make a reference under the said article even at an anterior stage. At any stage, President can, bring the question before the court. The satisfaction whether the question meets the prerequisites of Article 143 is essentially a matter for the President to decide. And upon receipt of a reference under Article 143(1) of the Constitution of India, the questions on which the President has made the reference on the facts as stated in the reference and report to the President its opinion thereon. However, the usage of the word may, this is important, the usage of the word may in the latter part of Article 143, Clause 1 of the Indian Constitution implies that court is not bound to render advisory opinion in every reference and may refuse to express its opinion for strong, compelling, and good reasons. Okay, so in this case, the court is basically looking at this may. The court may. Okay, the court may, after such hearing as it thinks fit, report to the President its opinion thereon. Now, in this case, the court is interpreting this may, okay, and saying that court may refuse to answer if there is a solid ground to that, if there is a compelling reason to not render the advisory jurisdiction on the issue that has been referred to the bench by the President of India. Okay, so may, the usage of word may and not shall in the latter part of Article 143 can be plainly interpreted that court is not always bound to render advisory opinion in all the references that President is bringing upon, and the court may refuse to express the opinion, but the reasons, they need to be strong, compelling, and good reasons. So some reasons could be the questions are hypothetical, they do not entertain the public interest, and if sometimes the questions enter into policy or political domains, then the court may draw itself back and not answer the questions that are raised in Article 143. Now, the court, herein the court is saying that this case, now the court herein is saying that presidents invokes judicial wisdoms by way of Article 143, and the Supreme Court responds back and respects the referral by rendering the opinion to the President of India, right? So in this case, basically the court is saying that what is the scope of Article 143 jurisdiction? How do you decide whether what petitions are to be entertained under Article 143 or not? So can the issues to sum up herein is that whether President needs to have a doubt, especially to come in the Article 143 jurisdiction? The answer is no. if it is a simple legal question, a question of law or a fact that is of public importance, and the opinion and the advice is needed, the president may, recon the jurisdiction under Article 143. The opinion rendered by the courts in Article 143 jurisdiction is not a binding one, though a persuasive one. The president, it is only advice because there is no adjudication involved, right? Now, the can court refuse to give the advisory gives the advice under 143 of the Constitution? The answer is yes, but with only strong, compelling, and the reasons where the matter does not seems to be in so much of public importance, or the matter is either slipping into a political or a vague domain, right? Now, the courts in this case is answering for the auction mainly, that auction is most reliable method for allocation of public resource of natural resources. But if there are other methods that can be used which are fair, transparent, they can also be used. And the court in this case is answering the presidential reference, answering the question that has been raised by the president in this case. And because these questions pertain to natural resources, and natural resources of course is a matter of public importance and does find constitutional importance as well, right? So in this dialogue, the judiciary advised the executive, clarified its ruling, strengthened the spirit of constitutional accountability, and to sum it up, court is mainly expounding upon Article 143 of the Constitution of India. Now, this case is also showcasing checks and balances under the Constitution. President as an executive, head of the executive, invoking judicial wisdom, and Supreme Court also respected the reference, presidential reference, without stepping into the shoes of executive, but rather clarifying its own stance, clarifying that no auction is not the permissible method, but maybe it is the best suited method for allocation of the resources, specifically in the 2G spectrum case. Okay. Now, this is it for the video on in re presidential reference of 2012. I hope the discussion was useful. If you found this video useful, don't forget to like, share, and subscribe for more on Indian Constitution, Supreme Court cases, other AOR cases, and other public law, private law insights. All right. Thank you everyone for watching. Please stay tuned with Legal Darshan. Have a great day.